Hey out there, legal warriors. Minor DUI. Is that a criminal charge in Washington State? Actually, it's not. There is a special charge in Washington State that covers people under 21 driving after consuming alcohol or marijuana, and I'm going to cover it in this video. There's some important things that you should know. So if you're interested in this area of the law, stay tuned. This is the video for you. My name is Attorney Lance Fryrear. I'm a defense attorney in Lynnwood, Washington. My law firm's been defending people charged with crimes all throughout Washington State for more than 20 years, and it's about to be 25 years here in about 30 to 60 days from now. And I'm putting out these videos to help educate the public. So if you find this useful, please like, please subscribe. I want more people to see it. More people need to get some help. Now I'm just going to jump right into it. Minor DUI, what do people think that means? They think that's like, hey, it's someone under 21 that gets a DUI, so therefore they must not be so hard on them because they're young, right? Well, that's not exactly right. In Washington State, there is a law, 46.61.503. That's a revised code of Washington if you want to type it in. And it is actually called driver under 21 consuming alcohol or cannabis. Why can't the legislature just say marijuana? I don't know. So driver under 21 consuming alcohol or cannabis. And that law has different penalties than a regular DUI, has different license suspension things than a regular DUI, and has totally different elements than a regular DUI. So what do I mean by elements? Well, elements are what the state has to prove under a law, a statute, to show that someone's guilty of violating the law. And so if we were to take a look at this particular law, it says that someone's guilty of driver under 21 consuming alcohol or cannabis if they drive a motor vehicle in Washington State while they're under 21 years of age, and they have a breath test or blood result within 2 hours of driving, more and more things, right, that has a result of, for alcohol of 0.02 to 0.079. So listen to that. The result has to be, as an element, 0.02 to 0.079 if we're talking about alcohol. So why is that important? Well, what if your result was 0.01? Would that match the elements? No. Wouldn't match the elements. You couldn't be found guilty of that. That makes sense because you're less, right? But let's say you blew 0.09 and you're 17 years old. Would you be charged under the minor DUI statute? No, you couldn't be, because your breath test is not between 0.02 and 0.079. In this case, it's 0.09. So now you just have to go to the default DUI statute where it doesn't care what age we are. Now, if we look at marijuana, same type of idea. In Washington State, the regular DUI charge says you're automatically guilty of a marijuana DUI if you have a blood result of 5 nanograms of marijuana or more within 2 hours of driving. And as far as this minor DUI, which it's not exactly what it's called, but it's easier to say, your result to be guilty there, the element says you have to be above 0 and less than 5 nanograms. So let's say you get a blood result as a minor and you come back at 4 nanograms. Well, yes, you could be prosecuted under this statute. What if you come back at 6 nanograms? Well, you're under 21. Shouldn't you be under this minor law? No, you can't be because you're above that 5. So now we go to the default DUI statute. Why do we care? Right? It's just a video to watch for no reason. No, we care because there are different consequences based upon what statute is being used against the driver. And the consequences are mainly on the criminal court side. And why do I say the criminal court side? Well, because there's also the civil action against one's license. So I'm going to cover that next. But let's talk about the criminal court side. On a regular DUI, if we're convicted of a regular DUI, on a first offense, you're going to have a minimum penalty of either 1 day mandatory jail or 2 days mandatory jail, depending on what your breath test is. Again, if you have no record. And that's jail time we have to do unless we get converted to a whole bunch of community service. If we get convicted of the other statute involving the minor, there is no mandatory jail time. The court doesn't have to put us in jail. Additionally, if we get convicted of the adult, the regular DUI, we're not going to call it the adult DUI, the regular DUI, we're going to have a mandatory license suspension. It depends on your breath test. It could be 90 days, it could be a year, it could be 2 years on a refusal. We're not going to have a mandatory criminal-based suspension on the other statute involving the people under 21 if they fit under that statute. So that's a big deal. And the other difference for the criminal side is the maximum penalty, and it's quite a difference. For the regular DUI, it's a gross misdemeanor, 364 days in jail and a $5,000 fine maximum. For the minor charge, it's only a simple misdemeanor, which means the maximum penalty is 90 days in jail and a $1,000 fine. So quite a bit different for the maximums, although usually we don't need to worry about the maximum because first-time people in trouble aren't going to get the maximum unless they say something pretty bad to the court. So practice pointer here. Let's imagine a situation where somebody who's under 21 gets pulled over for investigation of a DUI, and they get arrested and they get taken to the police station. They get asked to take a breath test. Let's say they refuse to take the breath test. What happens now? Well, we know they can't prosecute them under the minor statute because there's no breath test between .02 and .079. So what's the officer going to do? They're going to ask for a search warrant for blood. It's pretty easy for officers to get search warrants for blood nowadays because of all the marijuana DUIs out there. They email the judge, and judge isn't happy. It's 2 a.m. They get a notice. They electronically sign a search warrant, and now they go draw the blood. So what happens? Well, does the prosecutor go ahead and pursue the person under 21 for this statute immediately? Well, probably not, because they're waiting for the blood draw. But nowadays in Washington State, it's taken a year or longer on average for a blood draw to come back. So why do we care? Well, for this minor charge, the statute of limitations for a simple misdemeanor is only 12 months. The regular DUI, the statute of limitations is 24 months. And so what can happen in these situations is the ability to charge the person under 21 with that special charge may run out while they're waiting for the blood draw to come back. And that may work in someone's favor or it may work against them. It depends on the culture of the prosecutor's office. The prosecutor might look, let's say the blood draw comes back 05, and they think, well, we could have charged this as a minor, but there's not enough time now. So are we just not going to charge anything? Or do we want to charge the regular DUI because that's all we still have left in our statute of limitations? But does that really seem fair? So it's just something to think about, and I don't know that most prosecutors have thought about that, so I hope none are watching. So let's move on to the civil side. Remember I said there's a difference on the criminal side, which we just covered. There's a difference on the civil side as well. What do I mean by the civil side? Well, in Washington State, if a police officer stops someone for DUI and they arrest them and there's a breath test above .08, then they're supposed to send in a notice to Department of Licensing, and Department of Licensing then takes an action to suspend the driver's license regardless of what happens in the criminal case. We have plenty of videos on that. And so if you want to look at that, look up Department of Licensing, search this channel for that, DOL hearing, that type of stuff. But for a minor, if you're under 21, what triggers that administrative license suspension is not a .08 or higher, it's a .02 or higher. So if you happen to be under 21 and you get a breath test of a .02, a .03, a .04, if you call an attorney, they don't ask the right questions, they may think, oh, you're good, you didn't blow .08. You're not good, okay? If you blow .02 or higher, you're going to get a triggered license suspension based upon that lower standard for people who aren't supposed to be drinking anyway if you're under 21. So if you have a .02 or higher, I want to make sure you request that licensing hearing. Additionally, if you refuse, if a person who's an adult refuses a breath test or the person who's a minor refuses a breath test, in both of those instances that will trigger a license suspension. The officer sends in the notice. Now the Department of Licensing sends you something saying we're going to suspend you for a year because you refuse. So you need to request that licensing hearing if you're a minor. So what do we do? What do we do if we got pulled over and we're under 21 and we're dealing with this, or our kid got pulled over under 21 and we're dealing with this? Well, the first thing is take a look at the breath test. If you're between a .02 and a .079, then it's likely going to be charged as the special statute. If you're refused and there's a blood draw, there's going to be a delay, probably. And if you have a breath test that's .08 or higher, just realize even though we're under 21, it's got to be prosecuted by law under that regular statute, the regular DUI statute, because there's no way for them to use this special statute under 4661-503. Most importantly, if this happens, don't panic. reach out to a local attorney, reach out to someone who's going to know if you're going to have court or not. Remember, state cases, you're not going to have court right away. City cases, you may have court the next day. It's just difference in jurisdiction and how things work. And it can be really confusing. We had a case recently that sort of checked all these boxes where it's just it was a big old mess of confusion. Luckily, we knew enough what to expect. But, I want to just put out these videos to give you some idea what to expect, because this is a really scary time if you're going through something like this. So I hope you found this useful. If so, please like and please subscribe. More people get to see it. More people get the help they need. More importantly, if you have a criminal matter in Washington State, feel free to reach out to my firm. We've been doing this for more than 20 years. If we get on board, we'll listen to what happened, we'll identify a way forward, and we will be there for you. Thank you.